Okay, so I'm going to start out since there's only a couple of the wholesalers raised their hands. We'll get to that last. I'm going to kind of talk about the landlord-tenant industry and what's happening. And usually what happens is when I speak to a group, I'm never invited back because I'm the regulation guy. Everything you see on like YouTube and all of that is about how you can, get rich and passive income and all of that. But what they don't tell you is after you get the asset, now you got to deal with this jurisdiction and this law and that whatever. And then what happens is they get themselves in a bind and they come and see people like me. I'm not very fun. I like the regulation stuff. And so people say I scare the crap out of them when I do these things, but you got to know what's going on, and it's pretty ugly out there. So anyways, if you guys are landlords or you just want to do something, I have a platform called Nebraska Landlord, and I have a weekly email that goes out, and it's pretty intense on things, and I like to give a lot of great information to you guys. So if you want to sign up, nebraskalandlord.com. It'll take you to the landing page, and then you can put your email address in there. I got a really good one coming out tomorrow. It's a 10-part series on lead paint, the whole lead-based paint industry, and that one there is one I really scare people on. So I will tell you, honest disclosure, at one point in my life, I owned over 100 single-family rentals. They were all pre-78. Today, I own 0 pre-1978 for a reason. We're going to talk about that in a little bit. But first, I want to talk about what's happening in the Nebraska legislature. Anytime the Nebraska legislature gets in town and they start throwing out, right now, I think day 4, there's 200 legislative bills that have been put forward. There's only 4 that deal with landlord-tenant. As of today, I anticipate probably about 20 or 25 by the end of the session that we'll see. Last year, there was 24. That seems to be the magic number. So what's out there right now? The first one is LB 17. And LB 17, Legislative Bill 17, says the landlords cannot charge fees. And what it basically says that you are allowed to charge a fair rent, which is interesting, and collect a security deposit that's allowed under the Nebraska Landlord-Tenant Act, and that's it. In fact, application fees, you can only charge the amount that you are charged. You cannot up it at all. And you have to, and this is the interesting thing, is you're going to have to, as it's written, here's one of the unintended consequences that someone that's not in the industry when they write these bills don't understand. The way that it's structured is you're collecting all of these applications and they're paying you the application fee. You're going to have to take it first come, first serve. So you're going to have to do the application that comes in first, which you should do anyways for fair housing reasons. But you have to wait if someone is qualified to see what they're going to do before you can move on to the next one. Otherwise, you're going to have to refund the second, the third, the fourth, and the fifth their application fee back. That's going to be one of the unintended consequences to LB 17, as I read it anyways. So we'll see what happens with that. The next one is LB 92, the Residential Clean Slate Act. And I want to talk about this one because on the national level, we're seeing a whole lot of things going on with protecting like the background checks of the applicants, just people in general. And it's having a consequence in that there's not a lot of information that's out there that you and I need to conduct business, especially in the rental property world. It's not just that, it's for security clearances and for hiring and whatnot. But it's interesting because these 4 bills so far that I have reviewed, there's a national push for these things. You can go to the other states that are putting together the same type of proposals for legislation, and they're written almost identically. We're finding that there's a couple of really large nonprofit groups out of DC that's funding all of this, and they're funding money into the local nonprofits to then push these to the state legislatures to get these, and that's what's happening. But if the clean slate passes, we're going to have to deal with a couple of things. So the first thing is, if a tenant has their eviction case dismissed, or they're found not guilty, for example, it's automatic. The judge has to expunge or basically wipe the the slate clean. It also allows that if the tenant wasn't removed from the property, there was an eviction that was done, but the restitution order wasn't signed, and that happens a lot, way more than you think, then at that point, it was like the eviction never happened, and the record would have to be expunged. If the eviction was due to non-payment during a certain time period for COVID-19, they are exempted and it's going to be expunged, and there's a lot. So if there were evictions that were done during COVID or because of COVID, then they're going to be held not liable for it. And then the other thing is once an eviction becomes 3 years old, then the tenant can go in and request that their record be expunged as well. That means you can't have access to it. Now, this time, this legislative bill differs a little bit from last year in that it goes a little further and says that you as a housing provider, you can't ask about their eviction record. It's either on the report that you get or it's not. You cannot ask on an application, you can't ask in person, you can't ask at all. And if you do, they have a right to legally lie to you and tell you that there's nothing without penalty. That means you can't evict them, even though they're falsifying the application, you can't evict them. And if you do, there's a pretty hefty penalty involved. I do think that based on I talked to a state senator, I have a couple of state senators that I know. This actually might, because of the makeup of the committee that it's in, has a chance of actually making it to the general file. If it makes it to the general file, I think it passes. If this one, it's all going to be whether or not it makes it through committee, so we'll see what happens with that one. So the next one I want to talk about here is LB 101. This was a hot topic last year. It's a hot topic again this year. This is a tenant's right to a jury trial for evictions. Right now, the requirement under the Landlord-Tenant Act is it's a bench trial, which means the judge is the only one that can determine the case. They can't request a jury trial. No one can, because it's in the statute. So, this one is going to become law at some point. I need everybody to understand that. Because even if this doesn't pass, well, let's back up here. So what does this mean? So there are several jurisdictions, Philadelphia, Rochester, New York, and a few other jurisdictions that have trials where they can request a jury trial for evictions. Right now in the state of Nebraska, once all the paperwork is filed, a bench trial has to occur between 10 and 14 days. Okay? The parties can agree to stay it, but it never happens. That's kind of the benchmark. It removes that requirement, 10 to 14 days. So number one, there's several steps in the process in which the tenant must be notified that they have a right to a jury trial. Assuming they're notified in those different steps, they have a right, then the judge will basically, under the statute, would have the ability to basically place it in the docket wherever they want to put it. It could be in a week, 2 weeks, or 2 months, depending on the docket. Now, in Lancaster, Sarpy, and Douglas County, we have a lot of judges. But if you're out western Nebraska, where there's one judge that rotates between 5 or 6 counties, it could be a couple months before the eviction happens. There is a provision where the court may ask for, if they want a continuance or a jury trial and it's going to be unreasonable length, ask the tenant to pay the rent, or at least pay the rent to the court, and they'll hold it for those months that it could take. Says the judge may grant that. We'll see, it depends on the judge that you get. You all that have ever done an eviction, you know what judges are like. They do whatever they want, when they want, and there's not much you can do about it. So if you get a pro-tenant judge, that could be an issue. But here's where we find in the jurisdictions that have these laws, it takes about 6 to 9 months to do an eviction. And now that we have legal aid and all of those nonprofit legal groups coming down to the courthouse on eviction day, they're able to file continuances under this particular statute, if it passes, it's going to be substantial. This is probably the greatest threat to how we operate that any other legislative bill put forward. I think everybody from a risk management point of view needs to prepare for this, and I'll tell you why. It's going to become law, and here's why. So there was a case, NP Dodge versus Holcomb, 2023. It was a tenant that got evicted, and legal aid represented her, and legal aid's legal argument was, wait a minute, bench trials are unconstitutional. We should have the right to a jury trial. It went all the way to the Nebraska Supreme Court, and they threw it out, which was good, but they threw it out for one reason. They call it standing. They said that because the tenant, after the eviction, she was still there, voluntarily moved out, there was no reason to continue with the eviction legal proceedings, so that made it a moot point. That's why it got thrown out. Well, 3 out of the 7 Nebraska Supreme Court justices, in their decision, their concurrence, they call it a concurring decision, said, we need to revisit this. 3 out of 7 of the judges went on record to say, this is a basic fundamental right under the US Constitution. They have a right to a jury trial. So what that basically told all of us is the Supreme Court was saying, hey, legislature, you guys need to fix this or we will. Legal aid has another case making its way through the appeals process, on its way to this Nebraska Supreme Court. They're going to make sure that they have standing this time. I think in the next year or two, if the legislature doesn't pass it, it's going to become law in the next year or two. That's my opinion. And if I was a betting man, I'd have good odds on that. So that's something we're going to have to consider as we move forward. The problem if the Supreme Court makes the ruling, they make the ruling, they make it legal, and then it's the Wild West. There is no standardization. So every judge, every county is going to be able to do it differently until the legislature finally steps in and makes some kind of a semblance and some rules and procedures. So we'll see what happens with LB 101. And the last one just hit today. It's LB 185. For those of you that are in the realtor community, how many of you are realtors in here? So a fellow member, Rob Dover, he's a broker out of Norfolk. He's a property manager as well. He's a state senator, and he introduced 185, which basically is electronic notices are going to be okay. Believe it or not, right now in the state of Nebraska, what the law says is different than what everybody's doing when it comes to serving notices. The statute, I think it's 76-1431, says that notices, or I think 16 is the servicing statute and 31 is the notices. But anyways, whether any kind of notice, whether it's a 7-day notice, a 3-day notice, there's still a 3-day notice, believe it or not, or a 14, 30, a 30-day, or a 24-hour notice, all notices have to be served under the statute one of 2 ways: hand delivery, or it has to be first-class mail. That's it. Now, many of us have, and we should, we put into our leases that we agree that we'll use text, or the tenant can use text, or we'll use email, or whatever the case may be. And that's fine. And most judges will uphold that. As of late, they haven't been. So because legal aid and Creighton University and UNL and everybody's getting into going down and representing tenants at eviction day, they are using these loopholes to basically get continuances on evictions, to get the eviction thrown out and make the landlord start over with the notice process. So what I'm telling you is if you have in your lease right now that you guys can send your notices via email, and it's clearly spelled out in your lease, continue to do that, but just understand if you ever go to an eviction and legal aid shows up and represents that tenant, one of the things they're going to use as a legal defense is improper notice. And the judge, and many of them are right now, throwing the eviction out and making you start all over and reserve your notices by hand delivery or first-class mail. What this bill is trying to do is to codify what we're doing anyways. And that is to allow the tenant and the landlord to agree to alternative servicing requirements other than what's in the statute. Does that make sense? We'll see what happens. We thought it was going to pass last year, and then there was a fight over transgender rights between Rob Dover and State Senator Hunt, and she was the one on the committee that didn't move it forward. So, yes.
Can I put a plug in for Realty and SPOA that sponsored that bill with Senator Dover?
Yes.
That was our efforts that
So there.
that happened.
Reoma, everybody familiar with the Lincoln Group? It's the Real Estate Owners and Managers Association here in Lincoln. And then the State Property Owners Association, they worked with Rob Dover. I think the Apartment Association did as well, and there were some other stakeholders, but hopefully it'll pass this time. That's a great bill. It makes sense, and it basically modernizes what we're doing already. Just know if it doesn't pass, every time you put that in there, into your lease, that you can do email or whatever, it's always in jeopardy. And even worse are the landlords that sit down with their tenant and they come up with these agreements, like, hey, send me via email or text or whatever, and then there's nothing in your lease. There's nothing in your lease. You have no legal leg to stand on if there's an eviction.
What LB is that?
That is LB 185.
Does that go both ways for notice to vacate?
It does. You guys really need to make sure your leases are watertight. If you want to use mine, it's free. Just email me, help@nebraskalandlord.com. I'll mail it to you or email it to you. The current version is 24 pages. I'm doing a revision. I think it's going to be about 35 when it's done. You can cut and paste, do whatever you want. You just can't sell it. But I've actually had my lease make it to the Nebraska Supreme Court. They took down a Georgetown attorney, so. Yeah. Anyways, there's your little 6-page leases anymore just aren't cutting it. And they're poorly written. You have to really button up all your provisions. Things like this. If you want to be able to send your notices via email, then you need to make sure that it's clearly defined what everybody's responsibilities are, including the exact email address that you're going to send their notices to, and your email address for them to read, because they have a right to send you notices. Text messages. If you're going to do text messages for the 24-hour notices, same thing. But you better make sure that 24-hour notice that you text has all the requirements under the statute. Otherwise, it's an invalid notice. Right? Don't forget on your 24-hour notices, you have to tell the tenant the approximate time of entry, the approximate time of departure, the reason you're going. And it has to be a full 24 hours, and it has to be at reasonable times. That has to be in your text notice. Don't send a text notice if it's not in your lease. These are the things that are getting us in trouble when we get in front of the judges. Okay? I'm going to stop real quick. So far on the legislative bills, there's only 4 so far. Does anybody have any questions on those? Yes.
Okay, so with the whole clean slate, are you able to ask if the tenant has always paid their rent on time?
No, there is no provision in there. Not for that.
So you're not
California
able to
just
ask
passed a law
about-
where that had to be.
So you can't ask about eviction, and you can't ask if they paid rent on time?
Oh, paid rent on time. That doesn't address that part of it.
Okay.
It
So
just-
we can still ask when we're doing a.
Right.
Okay.
You can't evict, or you can't ask, if their record has been cleaned, you cannot go into that territory.
Right, but just
Dude,
asking,
this sounds
have
weird.
they always paid rent on time?
There's nothing in the statute or proposed statute that would not allow that. There's some other things that are in there. So for example, that you would have to comply with. Right now, y'all are familiar, you guys hear this?
Yeah.
That's okay? Okay.
Yep.
Adverse action report. That's if you do a credit check, and for whatever reason, there's some information on that credit check that says that you're not going to rent to them. Well, you would send an adverse action report that usually came from the credit report. Well, what you're going to have to do if it passes, they're entitled to a copy of it. You are going to have to give him a copy of it. You are.
Okay.
There's potential issues with the Fair Credit Reporting Act with that, but I'm just telling you what the statute says. Number two, is you will have to give them a reason why you denied them specifically. So maybe it's a prior landlord reference. You're gonna have to give the details of who the reporting person was, and the reason or whatever it was that they told you is the reason that you denied them. So if and this is gonna have ramifications, because how many of you receive phone calls from managers or landlords and they want to know, hey, Sarah Jones says that she rented from you. Would you recommend them? Right? We get that feedback. I'm not going to do it. I refuse to give feedback if this passes, because now I'm putting myself in a position where I might get sued for defamation. That's going to be a big thing if it passes. Yeah.
So when they sign the form saying, we give authorization for so-and-so to release information about us, and we say, no, they haven't paid rent, are we going to get in trouble because they signed the application saying they can release the information?
I don't know. I don't know what the intended consequences are going to be, both unintended and unintended. I don't know that specifically what's going to happen. My guess is if this passes, and we're not the first state where this is proposed. Colorado has almost a identical one, and what's happened is basically the tenant background check companies have taken the whole process over. They do it on your behalf. They send the tenant that, they give them the reason, you will report, they will contact you got to pay extra, but they'll contact the previous landlord or the previous property manager. They will have your tenant selection criteria to follow. They make the decision, so it kind of takes that out of your wheelhouse, but it's a lot more. And in Colorado, depending on where you live, you can't pass that on to the tenant. Like in Denver, you can't really do that. Pass that cost on. So
Even though they signed it saying
yes.
they can't.
The one thing about this particular bill, the Clean Slate Act, the way that it's written, is I think there's some Fair Credit Reporting Act issues that's going to have to be vetted first. So even if it passes, I think the Attorney General's office is going to have to really look at it. So, but it doesn't prevent them from passing. Question over here, yes.
Is there any reason that you can't give us a reason you were denied because there were other applicants that were stronger than you? That type of thing.
If you say that, it's okay if it's true, depending on the fact pattern to get there. I'm going to tell you guys something when it comes to the sales side and the property management side. We see different procedures. On the sales side, you may have 5 purchase contracts. You review each one and then pick the one that's the best. On the rental side, you really need to have a policy of where date and time stamp. So you're going to process the application in the order that they came. So application number 1 comes in and they're disqualified. Great, you send them an adverse action report. Number 2 is qualified. You call them immediately and say, hey, this property is yours if you want it. I'm going to continue running applications until you bring in the deposit or whatever it is that you use to take it off the market. Then you continue to do that all the way and continue to do it until one of the qualified applicants come in, and then they give you your money, and now it's legally rented. At that point, you could say there was somebody else that was not more qualified, but somebody else who was qualified came in and basically got it off the market. They were the first ones to come in. If you say better qualified, that is what we call a red herring or a trigger phrase in fair housing. And if that's a tester or they file a complaint with the Nebraska Equal Opportunity Commission, you're going to go down in front of the commission. You never want to tell them that somebody else is more qualified ever. Ever.
That's against statute, or why is that not okay?
It's a fair housing issue. It's a fair housing issue.
Can you just say, well, I think you're an asshole, I'd rather not rent?
No, you don't want to do that. No. You guys understand what fair housing, if you've ever been through a fair housing complaint, you'll understand what I mean. The best defense against fair housing complaint is never to get one in the first place and go to great lengths not to get them. Here's why. I will tell you, several years ago, I was on the board of directors of a large property management company, And then I love telling the story because it illustrates what I'm talking about here. We had an office downtown and we had like an 8-foot entry that was, there was an overhead at this 8-foot entry into our office. Had a homeless lady that slept there every single night. Every single morning, a staff would come in, give her a cup of coffee and a donut, and send her on her way until we closed. Did that for a couple of years. One day we didn't have a donut. She went down to the Fair Housing Center, made all these allegations that we were molesting her, blah, blah, blah. They filed a complaint on her behalf. 9 months later, $25,000 in legal fees. It was a unanimous decision. We won. That's what I'm talking about. They knew within the first hour this was bogus. That's why we follow processes. And when you start saying things like someone is more qualified, then they're going to want to see the qualification. Then your tenant selection policy becomes into question. That's one of the first things that the fair housing investigator asks for. What's your tenant selection criteria? You do have it in writing, right? How many of you have a written tenant selection policy? If you don't, and there's a fair housing investigation, you're going to get racked for that right then and there. That's the first one. Second one, when's the last time you had fair housing training? Oh, never? You're toast. They want to see annual fair housing training if you're in the rental property business. So I get what you're saying, but it's the technicality when it comes to fair housing processes. When there's a complaint that's filed, it's the process that gets you out of jeopardy. Documentation and processes. Did that answer your question? I hope.
Is there a law that says you have to have criteria?
Yeah, the Federal Fair Housing Act of 1968. Yeah.
Is there a law that you have to disclose your criteria?
No, there's no law yet. Not publicly.
To a tenant that asks?
The tenant asks that, no, you don't have to. But when a fair housing investigator comes in, you do have to provide. You are guilty until proven innocent. I don't care what they say.
Having all your paperwork.
So, all right. So another thing I want to bring, any other questions on any of that so far? All right, we doing
You
okay?
say the positive of eviction by trust. What's the positive there? You're sure it's headed that way?
Yeah.
That's rough. Where's the positive in that? I mean, even for the tenant,
The positive for the tenant is,
other than can stay without paying?
that's the positive. They're going to be able to stay longer. Now, a court can say if you want to go down the road of a jury trial, then you have to pay the amount of the rent into the court system and we'll hold it until I decide the case. But how many judges are going to do that? I can think of about half the judges in Douglas County, they're not going to do it. Lancaster, probably more than half are not going to do it.
I do have another question.
Sure.
So when you go to eviction and the tenant moves out, but leaves their stuff there.
Yes.
How do you get around removing their stuff? So if the eviction gets dropped because they've moved out, but their stuff is there and then they try to move in, or do we need to hold their
So
stuff for
as soon as they leave, you got to secure the premises,
Right.
right? And if you don't, they come back, then that's on you, right? But you secure the premises, but you also have to secure their goods under the Uniform Property Disposition Act.
But they did, right?
No. You have to secure it and then inventory it and determine its value. So if the value of their property is less than $2,000 and it's not what you think it is, there has to be an objective standard used. I used to use a used furniture dealer to come in. He had a shop and in South Omaha, and that's who would come in and give me an estimate of value. One of the things you want to do is look on electronics, because many tenants will rent electronics. And if it's Rent-A-Center or one of those, there'll be a tag on the back. You call them, they'll come and get it, and then the highly expensive stuff is gone. But if it's under $2,000, document it, inventory it, do whatever you want with it. It's yours, throw it away. You don't have to do anything with it. If the tenant comes calling and they sue you, then you need the documentation to say it was under $2,000. If it's over $2,000, I'll get to you in just a second. If it's over $2,000, this is when life sucks. Because you have to send a 14-day notice to them that, hey, we're going to auction off your stuff. Now, you can hand deliver it, or if you hand deliver it to the tenant, it's 7 days, but no one knows where the tenant is at this point. We don't know a forwarding address, so we send it to the last known address, which is the house. So you send this 14-day notice to the house, they don't respond. Then you have to, at that point, go and hire an auctioneer. And you have to then publish and set an auction date and then publish it into like the Douglas County Daily Record or your local newspaper, small town newspaper, somewhere where the tenant would reasonably read it if they read it, kind of deal. So they will, you publish it for 7 days, and then after the 7 days, you hold the auction. And you auction off their stuff. In the meantime, you are paying for storage, you are paying for the auctioneer, you're paying for the ads in the paper to publish it. The auction happens, if no one shows up, you're the person that, you bid on it, $1, it's done. But let's say that you are owed, let's say $1,000 for the storage fees and all that. And then an auction happens and you make $3,000. You can take your $1,000, but there's two extra $1,000 there. What do you do with it? Well, they stiffed you for, say, $2,500 in rent. You can't keep that $2,000. You have to send it to the state treasurer's unaccompanied personal property account at the state treasurer. Unless you have a judgment for that $2,500, then you can ask the court to transfer that $2,000 to you. That's what you have to do. Dealing with property is a lot different, like in Iowa. Anybody own property in Iowa? We call it conveniently curbside shopping. Because you throw it on the curb and everybody's looking for discounts. So, but kind of joking, but not. But yeah, the key is always to try to get that value under $2,000. And honestly, it's tough to get there. If there's no electronics, it's tough to reach that $2,000 threshold, unless they have a coin collection. I had one lady that had about $50,000 in a coin collection she left, only to find out it was stolen, so that was good. Had another tenant that was probably literally just in the cost of how much it cost them to purchase these DVDs, had about $90,000 in DVDs. The entire closet was full. And they were all copyright violated. So I called the FBI and they came and got them. So there are things we can do. Yeah.
I'm gonna plug in for Monpoa. The organization up in Omaha is the one that got that to the $2,000 level. It was at what, 250?
It was $250, and I think it might have made it to $1,000 and then $2,000, but originally it was $250.
Yeah, legislative efforts by landlord groups. Please join, support, donate.
It does help. Yeah. All right. Any other questions? Josh, Maria, Josh, how are you doing on time? You're my time.
You get plenty of time.
Man, I'll go till midnight. You'll all be
I get plenty of time.
Yeah. Any other questions before we move on to the next topic? I got to talk about lead-based paint because that's what I'm known for. In particular, I want to talk about the renovation, repair, and paint rule. I don't know if you ever heard of this. It's called RRP. Any house built prior to 1978, if you are a manager, a flipper, it's your second home. The only exemption is your primary residence, and residential is for residential property, or if it's like a commercial industrial property that is being used as a residential property illegally, violating zoning, then it falls under the act. You have to use You have to be an you have to use an EPA certified contractor to do the work. If you're going to disturb anything more than 6 square feet on the inside, 20 square feet on the exterior. So think about it. 6 square feet is about this big. So if you're going to do work in a pre-78 house, that means you have to use an RRP certified contractor. And well, you can be that contractor, but it has to be done and it has to be all the rules. So the reason I bring this up, friend of mine, and when it comes to lead, I get people all the time, okay, it's a rule, but no one does it. I used to eat lead when I was a kid, ha ha ha. But it's good. But guys, an issue is an issue only when it's an issue. And you could do this for 100 years, 1,000 transactions, and never get caught. And then, bam, one day you're a landlord in Omaha with 350 homes. been doing it 40 years. One tenant has 2 kids. Both kids test positive for high lead and they're jacked up. And it's permanent. They get sued. In the deposition, the landlord goes, I've never even heard of RRP. The result, $1.17 million per child was what they agreed to. Okay? And then a bunch of dumb school and all this other stuff that he had to do. He had to liquidate one third of his entire portfolio to pay it. There's no insurance. Talk to your insurance agent and see if they'll cover that. They won't. And the other thing is there's a law called the Comprehensive Environmental Reclamation and Liability Act. CERCLA is what we call it in the industry. It's the Superfund site. And it allows judges to dissolve LLCs, trusts, estates, corporations to get access to personal assets to pay a judgment when it's environmental. So, you guys, I bring this up because this recently happened. And a couple of days ago, I was just notified of a second case where a tenant, this is in Des Moines, it's going to be about $1 million per child because the landlord was not doing the work with lead safe practices with an RRP certified contractor. And I'm going to kind of get to that here in just a minute. This also applies to flippers. If you're a flipper and you're flipping a pre-78 house, you have to use RRP certified contractors. If you don't, it's your liability. If you're an agent representing or listing that property, you have a duty. In tort law, we call it the but-for rule. You should have known. That's standard practice in the industry that a flip house has to pre-78, it had to be done, and lead safe practices and all of that. You list that property, you're just as culpable. The only difference is your E&O insurance will probably cover that, where the flipper's insurance won't. Okay? So what I would suggest that you do if you're a landlord is there is a company, a training company called ZAC Academy. Z-A-K, ZAC Academy. They have a road show. Go take their 8-hour class. It's $175. They'll tell you all about RRP, how to get certified if you want to be certified, and then make the determination of what you're going to do. If you're going to be the contractor or if you're going to hire a contractor. That's where I always tell everybody to start. But there's certain requirements, like anytime you do any work, you have to test the area. That generates a report. You have to keep that report and all of that. And then it's the setup and the tear down. You have to use the plastics, wear the level 1 suit, have HIPAA filters to clean up, all of that stuff. And you never want to do that if there's a tenant in there, by the way. That's another issue. But I bring this to your attention because it's happening now. We're starting to see the nonprofit legal groups and here's how everybody's getting caught. At the kindergarten physical. Their kid goes in for their physical, they're testing them for lead, it's high, where's the first place they go? The house. And now the health department for that county's involved, and then all of a sudden people are calling from these nonprofits going, oh, hey, because that's kind of public record, and there was an incident. Next thing you know, they're recommending attorneys, and then the complaint comes. When it comes to lead, there is no statute of limitations. True story, I bought a rental property in 1995, sold it in 1997. 2018, I received a demand letter from a very prestigious law firm. The current owner of the property was being sued by the current tenant. Again, one tenant, there were 2 kids that were harmed by lead. I didn't even own the property when RRP in 2010 came into play. But everybody in the chain of title that was still alive, including an open estate and a trust, got a demand letter. So I took it to my attorney. They're like, I don't do federal court. So he hooked me up with a very expensive attorney that does federal court, $700 an hour. That's the going rate. He said, I can win. It'll cost you a minimum of $50,000. Let me see what I can do. And he came back and said $9,800 to make it go away. Everybody in the chain of title, except for the trust, settled for about 10 grand. So they made it quick, 60, 70,000 bucks. The trust fought it and they won, but it ended up being 160,000 in legal fees. That's the problem. So my point to all of this is, when you're dealing with pre-78 home, if you're a landlord, whether you're a manager, a flipper, it's your second home or whatever, this is when we want to make sure we're crossing our Ts and dotting our Is. There is no room whatsoever for, they have to understand I can't make money if I comply, because they don't care. Ask any EPA auditor and they'll tell you that. Okay? One other thing, raise your hand, third-party managers. So in April of 2022, there was a regulation that was reinterpreted. So if you were a landlord or a property manager and you were managing pre-78 homes, or you owned a pre-78 home, you had the option of either becoming an RRP certified contractor and doing your own work, or hiring it out to somebody. They revised that interpretation for third-party managers. You must have on staff an RRP certified contractor that is a W-2 employee. It can't be 1099. If you have no other W-2 employee, then you must go and get the certification yourself. You can still hire out a RRP certified contractor, but you have to be certified. So there's a lot of one-person shows out there, particularly in western and central Nebraska. So you gotta take that into consideration when you're talking about. Now, one thing you can't do is there's an administrative exemption, meaning you have nothing to do whatsoever with maintenance, including fielding the tenant's phone calls for maintenance. If you're gonna plead the administrative exemption, then it has to be in writing that all the tenants, they call the owner directly or some service directly. You have nothing to do with maintenance, period, not even taking phone calls. That's the only exemption. Okay? All right, we okay? Yes.
If you're a landlord, you get that exemption.
Well, if you're a landlord, you still have the option of becoming your own RRP or using an RRP certified contractor. You don't have to go down and get the certification. Third-party managers have it. They're compelled to. So you can do either one. What's that?
Would you recommend that, for those of us that have pre-78, go ahead and test them ahead of time? Because it's kind of spotty. When did they start cutting out the lead-based paint?
And so they stopped using it. The last supply had to be sold by July 1st of 1978.
But it was less, it was kind of phasing out before that.
1960, it started phasing out.
Yeah.
Yeah. So I can't advise you. That's something you have to talk to your attorney about. But I will tell you this: Selden Company. There was a time. Bob Dean was his name. He was the vice president of all of their residential. They finally made a decision because they were spending. I was in a class with him several years ago, and he said they were spending about $18,000 a month. They were giving to the EPA different properties for audits and stuff. And he finally said. Ted Selden went in and said, screw it. And they remediated all their properties, spent millions doing it. So they're lead free. That's a decision you're going to have to make. I personally here's what I would do personally. I sold every 1978 home I had. That's what I did. I definitely wouldn't buy anything older than 1960. That's me personally. Managers, I wouldn't manage anything before 1960. Me personally. It's a business decision. That's something you guys are going to have to make a decision on.
Do you have a sense of what, like, if there's never been any major, we've never done any major the major renovation type stuff, I'm assuming that lowers the risk because there was less of a history of being disturbed.
Actually, when you do renovations, it substantially increases the
Yeah,
risk.
so I'm saying if you don't have that history, the risk is reduced.
It can be. But the problem you have is if a kid tests positive, they always come to the house first. And then they may find out it's a toy or the candy from Mexico or China, but they always come to the homeowner first.
Yep.
That's what happens.
Say you buy a home, pre-78 home that someone else renovated, say they renovated it with RRP certified contractor. If you own the home, are you gonna be liable for a complaint in the future?
You're always liable, always. But there's culpability and there's what we call mitigating circumstances to all of this. And you can say, well, hey, I did hire somebody. And they have to maintain liability insurance for that very reason. And that's the beauty of using a contractor. All right, what I want to do now is talk about a couple of things with wholesaling. And this is actually fun. I did a podcast the other day and we were talking about this, and there was a room of us and they're like, well, this is illegal and this is illegal and this is illegal and so on and so forth. So when Josh and I talked, I said, I want to talk about some of the things that kind of cure or clean up some of the misconceptions out there. The first thing I want to do on this whiteboard here is kind of outline what a wholesale transaction looked like for those that don't know. We have the wholesaler who is the investor. We have a property owner, and the wholesaler and the property owner, they go out and they put a purchase agreement in place between these two parties. Then what happens is the wholesaler goes out and finds an end buyer. And the end buyer, once they're found, the wholesaler then enters into what's called an assignment contract. An assignment contract assigns the wholesaler's interest in the purchase contract to the end buyer. So when it goes to closing, we have the end buyer closing with the property owner. Now, let's say the purchase agreement between the property owner and the wholesale, the price was $100,000. Well, the wholesaler, when they find the end buyer, what they're going to do is include what's called an assignment fee. So let's say the assignment fee is $50,000. That means that the end buyer total is going to pay $150,000. The property owner is going to get $100K, the wholesaler is going to keep $50,000, and then everybody's happy. That is the essence of a wholesale transaction. So when they passed LD 892 a couple of years ago, they were trying to weed out the predatory side of wholesaling. And because, like it or not, wholesaling is 100% perceived as predatory. Make no mistake about it. I do believe there is valid situations. I always like to tell this story. In fact, I was talking to the Real Estate Commission when they were trying to draft their proposed legislation because they just wanted to outlaw it, just make it all illegal. Philadelphia had done it. Baltimore, Maryland, they had just said wholesaling's done, it's illegal, period. And I said, the problem is there's some legitimate reasons why we want to do it. And they said, name one. And I said, I have two. Because when wholesaling was going on as the director of Randall School, I'm kind of like the third party, disinterested third party where you can go and get honest information. So I would have property owners, I would have wholesalers, I would have the agents involved all calling me, and I was getting their contracts. And right now I have about 400 wholesale transaction contracts at the school from the last 4 years. And I started calling some of the property owners and I was like, why are you doing this? I mean, you're leaving tens of thousands of dollars of equity right at the table. Two things came really, were very prominent, the responses. And I love this. Ladies, hell knows no fury like a woman scorned, I think is what it is. The first one was, and this was about 40% of the 70 people that I called. That dirty son of a bitch cheated on me with a woman 25 years younger. I had to sell the house, and he thinks he's going to take $200,000 in equity and take his new woman down to Cancun on a vacation. Not happening. He ain't getting money. I ain't getting no money. The second one was estates. Mom died. I took care of her the last 5 years with cancer. Now all the siblings want to show up and they want their share. No one's getting nothing. Right? As long as they're informed, who are we to say they can't make that decision? Make sense? So I went to the commission. I was like, listen, you can't make it illegal because there is a valid reason. I mean, it's a free country. We can make a decision bad if we think it's bad, but it is what it is. So they said, we're going to cut and paste the Oklahoma law. The Oklahoma law deals with marketing. And it is not illegal to wholesale in the state of Nebraska. The wholesaler can go out and procure this purchase agreement. Nothing wrong with that. It's not illegal. The problem is, once you get that purchase agreement in place, now you gotta go find this end buyer. That is considered marketing, and that's when the rules come into play at this point of the transaction. So what is the rules? Number one, you must list your equitable interest in that contract with a licensed real estate agent in the state of Nebraska. One of the things I hear all the time is, well, I'm a licensed agent, so I'm exempted. That was the original proposal, but they removed that. If you're a licensed agent, that's great, but now you have to list it with your broker. The equitable interest in that purchase agreement must be listed with the broker. And it sucks because under license law, we have a for sale by owner exemption, meaning if you own your own property, you can sell the property for sale by owner. And there's nothing in the statute that says if it's a wholesale transaction, you can't do that. There's nothing in there that prohibits you. And I get this pushback all the time. Well, I read the statute and I don't have to list it with the broker because the statute doesn't say that. And I say, you're absolutely right. There is a Nebraska Supreme Court case called Choice Homes versus Donner, where the Supreme Court was dealing with a real estate issue, and they said, if anyone is going to sell equitable interest in a contract, then it must be listed with a real estate broker. That's why you must list your equitable interest with a real estate broker. You cannot do it yourself. How broad is that requirement? It is absolute. There are no loopholes. Wholesaler will say, no big deal. I have my own pre-existing list of buyers. Under Nebraska license law, the way that the rules are written, you cannot contact that list. You must turn it over to your agent for that agent to contact your list. Only your listing agent can market that equitable interest in any way whatsoever. You cannot text anybody, tell anybody, you can't sign language anybody, send Morse code, nothing. Once you're trying to market that equitable interest, only the listing agent can do that. That is the difference. Yes. Oh, you have a question? No? Okay. Yeah.
The entire statute is contingent upon the property being under contract first, correct?
Yeah, because that's where the equitable interest comes into play.
So if the property is not under contract, you can market to your heart's content, is that correct?
What are you marketing?
Potential
Potential
opportunity.
opportunity.
A potential opportunity, okay, in what?
Don't know, I guess I'm kind of marketing bullshit.
Right, but I mean, okay, vague in general is fine, but at some point I'm an interested person, right? And I say, okay, I'm interested, what are you selling me here? I'm the end buyer at this point.
Yep.
You don't have anything under contract, now what?
Right.
I come to you and say, hey, okay, I read your Facebook post, what do you got?
Then you go to a contract together.
The problem is, if you say, okay, this is what I do, I'm gonna go find you a contract. Your intent is to wholesale. Greg Lemon with the Nebraska Real Estate Commission said, we will take that to trial. There is absolutely no circumventing. Now, he said they're more than welcome to go to court and try to get it overturned, our decision overturned, but we would file a complaint. If your intent is to wholesale and your intent is to circumvent the law, then that's a violation.
That's how they feel about it. Have they tried it that way in the courts?
No, they won't. I mean, the real estate commission's gonna do theirs, they're gonna come down with a judgment, then it's up to you to then go and file the appeal. I will say that their decisions are always vetted by the Nebraska Attorney General's office, so they got, on this whole regulation, they got the Attorney General's office blessing.
Okay. But technically, that does not follow the statute, correct? Because any marketing you did was pre-contract, not post.
I get what you're saying, I'm just saying, this is what they told me. Trust me, don't shoot the
I
messenger.
appreciate the feedback, just
Yeah.
statute versus what the real estate commission is choosing to do.
The other problem you're gonna have is at the point you say, listen, I have a property that's identified and I think I can put something together. Once you put it together, you can't talk about it at all. you're done unless it's listed, even if we already have this relationship. Number two, if you go too far into the details, you better have permission from the owner to release that information. Otherwise, that is a license law violation because you're acting as a broker without a listing contract. That's how they get you. So if you start telling me, listen, I'm talking to this owner, it's at 123 Main Street, it's 3 bedrooms, 2 bath, boom, that's a straight up violation. They would nail you for advertising a property you don't have listed and you're not
What
licensed.
if you never had equitable interest in the first place?
I'm just saying that's how they're gonna do it. They're gonna build that case.
End buyer makes the original contract from the beginning, no?
The end buyer makes the original contact,
Contract.
or makes the original well, if the end buyer makes the original contract with the property owner,
Yep.
then you're not gonna be in it anyways as a wholesaler. I mean,
That paper.
so just so you know, they're not playing now. So I don't know, how many of you are agents, real estate agents? How many of you like to read the commission notes, the Nebraska Real Estate Commission? So there's a newsletter that goes out about all the penalties. So a couple years ago, they changed the law that said that the maximum fee or the maximum civil penalty is $5,000 or the amount of the commission earned. You're not licensed. But the law says that if you are acting like a real estate broker, then those sanctions apply. So a wholesaler just got busted for the entire gain of the transaction. He had made a $20,000 off an assignment contract off a deal like this, and they took every penny of it. And you know who's ratting you out? Agents and other wholesalers. You want to know how I know that? Freedom of Information Act request. Every once in a while, I will do a FOIA request to the Real Estate Commission Director and say, it's May of 2023, I want every email that the commission received on wholesaling, and they have to give it to you. Names and everything. It can be expensive because there's a lot of pages sometimes. And I know a lot of the wholesalers in the industry. It's agents and it's other wholesalers turning other ones in. One other thing, I don't know who, if anybody in here owns a Facebook group, you need to police the posts. They were going after Cash up at Omaha Ria. Him and I had a conversation because I found out that they were looking. You're responsible to monitor those, whatever's advertised, you're responsible for what's advertised. And one of the requirements when you're advertising a wholesale transaction, it must have the name of the agent that it's listed with, because there's no FISBO exception. It must say that it has to say in any advertising, even word of mouth, you're required to disclose that it's an equitable interest that's for sale. If you have a for sale sign in the yard, it has to say that on the for sale sign. If it's on a flyer, if it's a Facebook post, you can't just say for sale. It has to say, it must say, even if you're fishing, like we just talked about, if the intent is a wholesale transaction, it would say this is an attempt to secure a wholesale transaction. It has to say that. There's another license law violation.
The definition of wholesale transaction is that there's an assignment agreement in place?
No, it's the sale of equitable title or equitable interest, means the same thing, in a contract, period.
Oh, so if you never had a contract in the first place, then you're not.
No, then they're gonna get you on something else, like advertising property that's not for sale or acting like a broker to solicit a real estate service. Trust me, dude, there is no roundabouts legally, none.
So there's no workaround, is what you're saying, and they're targeting wholesalers or anything like that? Yeah.
Here's the interesting part, and I don't agree with this, but they use the regulation, because think about this, you're selling an equitable interest in a contract, which fills the definition of an option contract. It is very common for developers to develop land, turn around, sell a lot to a builder on an option. They do a wholesale transaction by definition. So when this came out, they're like, holy crap, all the developers are going, we can't do this is gonna, so they cut out an exemption for raw land. So if you're out wholesaling raw land or farms and stuff, as long as it doesn't have a homestead on it, it's outside, that's the exemption now. Yes.
So in my opinion, the workaround, and correct me if I'm wrong, the workaround is to double close.
No,
It's not.
no, I'll tell you why.
Yeah.
I had about a 2-hour conversation. I actually went down to Lincoln and talked to Greg Lemon about it. By the way, Greg Lemon, the director of the commission, just retired. The new director is Joe Gerke. He was on the commission. He was the one who helped put this statute in place. And so he's going to be a lot less lenient than Greg Lemon was with a lot of this stuff. So here's why double closes don't work. As soon as you secure your purchase agreement, right? Then how did you communicate to find that end buyer for the double close?
So, okay, so let me clarify. I guess I meant double close and then start marketing it once I.
Okay, so if you close on this property, you're the legal title holder, so then none of this applies. You can do FISBO, everything.
Yeah, I just want to clarify.
But that's a great question, because a lot of the wholesalers will say, let's not just double close, that's the exemption. You cannot do that because at some point, once this went under contract, you had to tell somebody, text somebody, email somebody, post something to find this end buyer. Now you're in violation unless it's listed by a real estate agent. And then you'll say, well, but it was a previous list that I had, or it was a conversation that I had previously. The commission, if they find out, is going to come after you because your intent was the wholesale. Again, I think a court would probably overturn that, me personally, but who wants to be in the case of first impressions and spend the $30,000 or $40,000 to try to get the ruling when there's no guarantee? That's why the double close doesn't work either.
Unless you wait to market it until
After you close. Yeah, then you can, because then you own it.
Yeah.
Right.
You were marketing, you were bragging about the deal you got. There you go. Trying to give me more.
One other thing I will tell you need to be careful of, and I have seen, I have 381 packages, wholesale packages going back to 2019. And when a seller or when a property owner calls or a wholesaler, I want the whole packet so I can give counsel, my opinion on things. It is amazing what wholesalers put in emails. Almost all of them had some kind of verbiage that was a total lie, which is fraud. They would say, hey, we think your house is worth $100,000. It's really worth $250,000. I need to do $40,000 worth of work to get it on the market. And by the way, they do $0 worth of work. Then all of a sudden they're turning around and selling it for $250,000. Now that is straight up not only a license law violation, even if you're unlicensed, but because it's a real estate transaction, it's subject to the license law. But now you have a problem with the Attorney General's office. So be careful what you put into writing. The last thing I'll say here, and then I'll open it up for questions, and then we can start moving forward. If you're a listing agent right here, so the wholesaler does it right. They get their contract, they contract you, the listing agent, to list this. Make sure you get a copy of the purchase contract between the property owner and the wholesaler. The wholesaler isn't going to want to give that up, but you have to, because we have to make sure that it's actually a legally binding contract in Nebraska, because without a legally binding contract in Nebraska, we have no equitable interest to sell. It is the same as selling a property or listing a property for sale where you don't have a listing contract, or you're selling somebody's house that they don't own. There's certain essential elements, as you learned in pre-licensing. You know, it's got to have a closing date. It can't be to be determined. It has to have consideration in there, etc. So that's number one. The second thing to remember is you're going to need permission slips. Remember this thing called agency? That agency document that we have? You have to have an agency with the wholesaler as a client, the property owner as a customer. Then you have to have the customer sign a permission slip that gives you the right to market the details of their property. You cannot allow the wholesaler to go and get those documents signed for you. You, as the listing agent, must go to the property owner and get it signed directly. You can do it by DocuSign, but the point is you have to make sure that you do it, not the wholesaler.
Can you run a scenario that makes sense to legally go through this? When does that work? It actually logically make sense.
What part? What do you mean?
I want a wholesale property.
Yeah.
Does that logically make sense?
So that's like a 3-hour continuing ed class. It really is. I actually teach one and we break it down from the beginning all the way to the end because there's so many variables. For here, I was just kind of assuming everybody's kind of already familiar with it and I'm trying to hit the high points, the things that I hear a lot out there, like this is illegal, that's illegal, or I can do that. And I wanted to clarify all of those. I know we have, listen, at Nebraska Realty, that's where my license is at. We have a wholesaler, and he does it the right way. He goes out, he secures the purchase agreement between the property owner and himself. He is a licensed agent, so he lists that equitable interest with the brokerage firm. He signs his own listing, right? It's legal, and then he markets it. I mean, that's,
And it's Nebraska Realty and like Realty wants Sterling Group, they're about the only two that'll do it in Omaha.
I think you're right. Most brokers won't allow it. And in fact,
So liable.
the MLSs, they don't allow those transactions to be put in there.
But you've added a layer of extra problems for everybody involved.
Yeah.
Why not go collect, go collect the result?
I don't disagree. I'm just saying that's,
Well, like I said, logically, where does that make sense?
logically what happened is when the law passed, all the major players got out. T-Square was a company out of Wheaton, Illinois. They were spending $100,000 a month in Omaha alone. They're gone. They haven't been back since it passed. I mean, I don't know. So I feel like I just threw up all over all of you. Anybody have any, how are we doing on time, Josh?
You're good. I think, yeah, questions now.
Yeah, questions? Questions on anything? I threw a lot at you, but yes, sir.
If you receive a postcard in the mail that talks about someone who wanted to buy your property,
Yes.
do they have to put their actual address on there of where they are actually at, or?
They do not. So if there's a postcard that's sent, they don't. However, I do want to point this out because you brought this up. If you're a licensed agent and you're buying your own property, many agents that are licensed, they send postcards out because they want to solicit to buy that property. You must disclose that you're a licensed agent now. It only used to be if you were listing your own property. Now, if you're soliciting to buy a property, you have to make the disclosure. But no, they don't have to put that on there. Good question. Yes,
The laid vest paint with flipping,
yeah.
walk me through that for a minute, like vacant property, how deep you have to go, walls and like, nobody's living there.
Yeah,
Having kids work there, you can't do that, like, where do you?
it all starts with getting either, when you're doing your assessment, you have to look at it through the assessment eyes of an RRP contractor, because they're gonna have to test in certain areas. The high point areas are mandated, like the porches and the windows and the doors, any areas where there's rubbing before you start doing renovation. There's documents that have to be generated in test reports. That's gonna determine how much plastic has to be hung and does it have to be sealed plastic or not? And what level of white, the white suits you have to wear. Type of filters, depending on the test results, and rubber gloves or no rubber gloves, and that all increases the cost. The EPA says it'll increase your cost about 10%. In reality, it's between 30 and 40%, to be honest. And so that's where it starts with the assessment. Now, either you've got the training and you're qualified to do all of that stuff, or you're legally required then to bring in a RRP certified contractor, because they're going to want to assess it before they bid the job. And that's where it all starts. To find out what areas are going to be, remediated or remodeled and which areas aren't. If you do it
I'm under the
correctly.
impression that if it's big remodel, have the spiel with the boys, don't walk home with your shoes and bring them in the house for your 2-year-old to lick the bottom of them. That's kind of it. Side of it, and I did the training. I'm pretty shady license contractor for it. I don't remember all the details, but it was kind of like, well, basically, if there's no tenants in there, there's no kids in there, give the spiel, document and gave the spiel, but you don't need to tent the whole house to tear out a floor, because you're gonna gut the place and start over. You don't need to tent the whole house, like, that's not a thing.
Well, if you're you have the areas that you're gonna do, the areas you intend to work on. So if you're intending to take the floor up, then there are certain areas it's gonna have to be tested depending on if there's, like varnishes. If that's a floor that was around prior to 1950, that varnish has lead in it, guarantee you. You know, so those are the variables. The thing you have to be careful, I know what you're saying, because I've been to the training several times myself, but here's the problem with that argument. It's the owner that buys it. And then all of a sudden their kid pops positive, they're coming right back at you, and then you're gonna have to be very detailed when discovery happens with the lawsuit of all of your records, documents, who you used, what kind of HEPA filters were used, what type of cleanup was done. And if
What
you
about
don't,
the after the fact, like, I have a multifamily, and it's partnered with the city, and they came in after the fact on
Right.
remodel. They tested everything to approve it. They're like, yep, everything is good. What if you did that?
You're still required.
Like, hey, we got done, we tested everything, all the surfaces are clear now. Mr. Tenant, don't take a dent out of the wall. Let us know if you do. That could be dangerous.
right, but you remember from training, you have to test before and after. So you have to test before you do the
Right.
project and
Right.
then after cleanup. If you can't provide
So if you
documents,
test
you
out,
did both.
you know,
You can't just do one.
What's that?
You can't just do one side, you have to do both sides.
Well,
I know the city, like Omaha comes in, they'll do the after the fact, you know, when it's done, but they don't do the before the construction. That's where the RRP contractor has to do it.
but where's the liability as the owner for your tenants if the after had been tested? Like, are you okay then or no?
You're never okay. Because remember, there's two parts to this. There's the regulatory side, the EPA enforcement. You might be okay on the EPA enforcement side. It's the tort law. When you get into court, when somebody sues you, it's a preponderance of the evidence. It's just barely 51%, if you will. And that's the problem with this. Anybody can sue anybody. Ernie Chambers sued God. He got his day in court. He didn't win. But it's federal court too. That's the other problem.
There's money spent.
So I throw that out there because you guys that are flipping, you gotta take that, calculate all of that into your expenses.
So nobody could be able to actually, there's no money made. to do it. I
Honestly,
don't know, you said that earlier. but-
honestly, if you do it right, it's challenging. I'm not gonna lie. My job is just to be the messenger.
On that note, is there like, let's say something happens, heaven forbid, on a house that we had owned 5 years ago, 10
Yeah.
years ago, whatever. And you don't own it anymore, but you own it with your LLC. They can go after you're saying they can go after
Yeah.
your LLC, but they can also go after you personally because you own LLC?
Well, once you break the corporate veil, then they can come after you. Yeah.
Okay. But it sounds like, what I heard you say, it sounds like some lawyers figured out this easy way to make money and go after everybody in the chain of title and get some quick cash.
Correct.
Okay.
That's what they did in my case. And what they've done with the CERCLA law is the CERCLA law was initially designed to go after big corporations that would hide behind, they would shut down this corporation and start another one, transfer the assets, and then guess what? There's no assets to get because this corporation that did all the polluting is now defunct. Well, they put a provision in there to be able to, oh yeah, we've seen that, so now we're gonna pierce that veil. So then they started applying it all the way down to our level. So that's an unintended consequence of the law that was originally intended to go after like the big polluters. Now, just remember, I'm the messenger, so I'm going out to the parking lot. Please don't shank me or anything. So- Any other questions? Anybody?
It's helpful.
Yeah.
I'm sorry, guys. I hate to be,
No, you know-
Josh is never going to ask me back. I like to get people to think about things because it matters. And again, I've been a victim of this stuff. I've just seen it. I do consulting. I travel across the country. I see it every day. In Maryland, it's so bad. The lead laws are so bad in Maryland, you can't even find a landlord anymore. It's all nonprofits and corporate landlords now. All the individual landlords are gone. That's the reality. And what happens on the East and West Coast come here. It just does.
How long does it take to get certified for that RV?
1 day, 8 hours.
1 day, okay.
8 hours, you pay $300 for the certification, you have to get an insurance binder, and then the certificate sent, the EPA will send you an ID.
If I'm already a contractor and I already have insurance, you said something about the insurance?
It's a special liability for environmental stuff.
Could I talk to my insurance company and see if they cover that?
What you're gonna wanna do is take the class first, because it's a certain type of coverage that you
Okay.
need, and then that your insurance agent, your company probably won't offer.
Okay.
Last I checked, there was only like one company on the planet that did. It was like some English company. Yeah, some weird name. Bank of, I don't remember.
Okay.
Lloyd's of London.
Yeah,
Lloyd's of
Lloyd's of
London.
London.
Like, oh, I didn't know, that, like I said earlier, I didn't know that.
Yes, ma'am.
Okay, I do have a question.
Perfect.
For, emotional support animals.
Okay, fire away.
So anything can be an emotional support animal, and then from what I've heard is you don't have to have like a doctor's note, anybody can write that they feel that you should have this emotional support animal.
So, okay, now, just so you know, there's no such, and under fair housing, there's no such thing as an emotional support animal. They're all assistance animals. So terminology matters, whether it's a seeing eye dog or a comfort animal for depression. There's 3 prongs to qualification. The first one is a disability exists. Second is there is a reliable third-party statement. A reliable third party is a healthcare professional, a priest, a pastor, somebody that gives counseling. That's a reliable third party. In some cases, it can be the parents, depending on the situation. The third part is there has to be a request made by the tenant. So the tenant comes to you and says, I'm going to get a dog, and you say, we have a no pets policy. And they say, well, I went to my doctor, or my husband and I are having problems, we're separated, and my counselor, boom, you know right away that what they're asking you for is an assistance animal. So you don't ask what their disability is. What you have to say is, whoever prescribed you or told you you need the animal, I need a statement from them, whether it's a doctor, whatever, and then they'll provide the statement for you. Once you get the statement, if it's legit, they get their animal. So be real careful on putting restrictions on what that statement looks like. I don't care if it's handwritten with a crayon on a napkin. If it's from a legitimate, reasonable, reliable third party, it's legit.
Second question, if somebody, say, has been living with you for a year, they've been paying pet rent, all of a sudden they turn their animal into,
Right. Legitimately.
do you have to reimburse them for their pet deposit, pet rent?
Okay. Whether you have to refund the pet deposit, there's
Even
no.
though they lived there when they didn't have their letter?
Right, exactly. So the pet deposit becomes, we don't know. There's not a lot of guidance. If you were to call a nonprofit, fair housing, they, oh yeah, you got to refund it. You talk to an attorney, they'd say, no, you're fine. You have to make a decision whether it's worth a potential fair housing complaint. Because remember, like suing anybody can file a complaint. However, pet rent has to stop immediately
Right,
the day you
it has
approve.
to stop.
And I think it's a good idea from a risk management point of view to then, let's say you find out on the 15th of the month, prorate 15 days because you collected ahead, right?
But you're not responsible for any of that.
No,
back. But
no,
as
no.
soon as they say, here's my stuff, everything has to
Yeah.
get,
Yeah,
you don't have to refund.
you do not. And boy, they try.
Oh, yes, they try.
They try. The other question, because this is going to come up, how many assistance animals can they have?
As many as they want.
Kind of. They're allowed 1 animal per disability per person, if it's reasonable. And that becomes the point that's argued, but that's the answer.
So if somebody has, well, if somebody has
They can have
multiple
100.
personalities, and they have an animal for all the personalities, do you get an application on each personality?
Boy, that's a good question. Here's what I would tell you guys, and I mean this sincerely. What's the best, I said it earlier, what's the best defense against a fair housing complaint? Never get one in the first place. So anytime you're gonna say no to an assistance animal, even if it's slam dunk legit, then you need to talk to your attorney first, just to make sure. I know it's a cost that you're gonna have to pay, but it pales in comparison next to a complaint that you're gonna have to deal with. And this is an area that's getting ridiculous. I'll kind of wrap it up with this. In Florida, look it up online, in Florida a couple years ago, there was a tenant down there in a independent living facility. He was entitled to an assistance animal and he wanted an alligator. They told him no, makes sense. He filed a complaint with the Florida Equal Opportunity Commission and won. They said, unless that alligator individually bites somebody's head off basically or gets aggressive, then you can make him get rid of that alligator, but then he's entitled to get another one. So that's where the industry's going. Yes, one last.
Funny you say that. In the county where I live, actually, I'm not allowed to have pit bulls, but I can own an alligator.
Well, if it's an assistance animal, then you can have a pit bull.
Nope.
Yeah, you can.
Yeah.
If they say no, they'll give you some advice. If they say no, and it's legitimately an assistance animal and it's yours, and you have it documented and all that, call the
I was
house.
gonna go get an alligator. I was gonna.
No, I'm saying, file a complaint against the city. The city of La Vista got nailed with a complaint because they had a statute or an ordinance for no chickens. No chickens whatsoever, and the tenant wanted a chicken. He was entitled to an assistance animal. The landlord's like, hey, I don't care, but it violates the ordinance. La Vista told the landlord, we'll prosecute you if you allow it. So the landlord and the tenant both went down to the Fair Housing Center and filed a complaint against La Vista. And La Vista capitulated. Council Bluffs has no pit bulls unless it's an assistance animal, because they're not pets.
You can't ask for documentation on a service animal, though, right?
You can't, well, under fair housing, no. You can't ask for documentation.
Say it's service animal.
If it's in the public domain under the ADA, that's a different story. Then other rules apply, because it's in the public domain and place of employment, things like that. So, yes.
Give a tenant sign a letting closure form,
Yep.
saying you don't know anything about it. Doesn't that get you off the line, or is that?
Okay, again, from a regulatory side, yes. Regulatory enforcement from the EPA, yes, you're good. It has nothing to do with the court side of things, the civil lawsuit side of things.
Even if you give them the pamphlet saying, hey, here's the.
Yep. Yep, if that kid positive for lead and there's harm, there's damages, you might be held accountable or liable for it.
So what's the point of the form?
They want to make sure that you notify the tenant if there is any documents or any issues that you know about that's lead related. You have to provide those to the tenant. And if you don't, then that's the reason for the disclosure, and then the civil penalties. Civil penalties now it's up to like $24,699 per violation now. So, yeah, it's no joke.